Thank you for the invitation. I'm so pleased to be with you here today. It's good to see such a great crowd. Welcome to all of you, and welcome to those of you who are participating on the live webinar out in the cyberspace. Welcome to all of you as well. I understand there's a mechanism by which you can ask questions, and we'll take up some of those questions toward the end if we have time. And those of you who are here in the live audience, please feel free to ask questions. This hopefully will be a very interactive and lively discussion. It's 4 o'clock, 4:15 on a warm fall day, and so you're probably sort of at the end of your gas in your tanks. So hopefully we can have an interactive and entertaining discussion. This is a topic about which I personally am very excited and interested in. By way of background, I was born and raised here in Boise, and decided to come back after my schooling to sort of I felt a loyalty to Boise. I wanted to grow the community and help the businesses here. My dad was a local businessman for 50 years here in Boise, so I felt strongly about helping local businesses. And my father was a broadcaster. He had radio stations. My nephew Phil is here, so he'll know some of these stories. My father was a broadcaster. He had radio. And I remember vividly that as a function of my father having radio stations, an organization called ASCAP would come once a year and perform audits on his books and records to determine which records had been played during the preceding year, because the artists, actually not the artist, interestingly enough, the songwriter makes money. There's no performance right royalty in the United States. I digress, but if you sing a song, you get no money when that's publicly performed. Only if you're the songwriter. Isn't that interesting? In any event, the ASCAP people would come and they would audit my dad's books and records, and that's copyright. American Society of Composers, Artists, and Performers. That's a copyright issue. And from the youngest age, I was fascinated in the concept that people could make money from doing nothing other than writing a song or performing a song or something like that. So as a function of watching the ASCAP auditors come and audit my dad's books and records, I developed an interest in copyright law and in the law more generally. And so we find ourselves here tonight with this topic in front of us: how to make money from your intellectual property in general. So the premise, one of the premises, premise I for tonight, is that you have a new app or a better mousetrap or an idea for a better, cooler thing. I'll get a call and someone will say, Brad, I have an idea for a thing. The objective, of course, is now what to do with that thing. And so the assumption underlying this discussion is that some of you will have an idea for a thing. Or perhaps you've already invented the thing, or you want to come up with it. What now? What do we do? How do we make money from it? So there are some assumptions that underlie tonight's discussion. The first assumption is that you are in a position to monetize and commercialize your products and services. That's possible on these facts. Number two, that you wish to do so. This is important because note the second bullet point. Some people have an open source mindset. There are a lot of code writers who contribute it to the common good, and they do not necessarily want to monetize that IP. GitHub and SourceForge are full of open source programs, right? And there's not necessarily an expectation of compensation. But tonight's assumption is that you have more of a capitalist bent, and you probably want to try to monetize that intellectual property, which is great. Third assumption is that your products and services do contain intellectual property. Most do. Some do not, but most do contain intellectual property. And we'll talk about that in great detail. And then lastly, IP has found money. It's like digging into the ground and coming up with a nugget of gold. Because if you think about it, the cost of goods sold on certain kinds of intellectual property is very low. Let's assume you write a best-selling novel. What's your cost of goods sold? Todd, what's the cost of goods sold in writing a best-selling novel? Yeah.
The computer time I use.
Right. Paper and ink, if you use paper and ink, the computer time, some electricity, nominal, isn't it? But what's the upside if you monetize that intellectual property, the copyright in that book that you've written, potentially millions of dollars? So it's literally the process of taking something in the ether, an idea, and conceptualizing it, making it tangible in some way, and then making money from it. It's found money. We don't have to have warehouses full of toasters. We don't have to have armed guards. We don't have to have warehouses with locks and fences around them. We simply come up with an idea. We use intellectual property constructs, and we monetize it, and we make money. It's just that simple. So the premise tonight is that you really can take these ideas and turn them into cash, hence the name of the seminar. From idea to exit, or from idea to cash, idea to exit, whatever we title it, that really is the premise. Okay, so in general, here are the reasons people build intellectual property portfolios. And let me pause and mention what we mean when we say intellectual property. It's an important distinction. In the law, we learned that there are three kinds of property. There's real property, which is dirt, generally speaking, dirt and things affixed to dirt. There's personal property, movable stuff like cars and shoes and computers. If you can move it off the dirt, it's typically personal property as opposed to something affixed to dirt, which is real property. And those are tangible constructs, right? Then lastly, we have something called intangible property or intellectual property. Why do we call it that? Because it only exists as an intellectual construct. I can show you evidence of a copyright, but we can't put a copyright in a box. We can show you evidence of this intellectual property, but it's an intellectual construct. So when we talk about intellectual property, we think of these intangible things, which again we'll discuss in great detail. So why do we do this? Why do we worry about this found money? Why do we build intellectual property portfolios? Well, the ways generally that you monetize it are you license it, you allow other people to use it, you sell parts of it, you sue people because they're infringing it, offensive use, you have it in your portfolio in case you get sued, and lastly, you want to sell the company, you want to have an exit. These are all reasons to amass an intellectual property portfolio. License it, which means allow other people to use it and sell you money. And give you money for the privilege. Think of a software license, or when you download an app on your phone, that's a license. They're allowing you to use it and pay you money. You pay them money for the privilege. You want to just simply sell it, divest yourself of the rights to it. You want to be able to go sue people for infringement, which we do a lot of. My patent partner, Phil McKay, is here, and as members of a law firm, we do a lot of that. We sue people for infringement to make money for our clients, sure. We want to be able to have defensive things in our portfolio, so when we get sued, we haul that stuff out. And lastly, when Google comes knocking and offers you $20 million, you want to have an exit. You want to have a cash payday, right? I mean, that's kind of the point. So there are a number of high-profile exits these days, right? Who can think of a recent high-profile exit? How much did Instagram go for? Was it $3 billion, I think, to Google? How much was it, Dallas? Well, anyway, Instagram sold for a boatload of money. And what was Instagram? It wasn't warehouses full of toasters. It was an idea, a trademark, maybe a patent. I don't know. Did Instagram have any patents? I doubt it. But you see the point? These Instagram guys came up with an idea, and they followed some of these principles, and bada bing, they make $2 billion. You can do the same thing. It's not hard. It really isn't hard. The trick, of course, is coming up with that idea. And every one of you has that earth-shaking billion-dollar idea. I know you do. You can think of it. And, of course, because of trolls, right? Trolls are the pejorative term that we use to describe people who do nothing but enforce intellectual property to make money. They don't make anything, they don't sell anything, they don't write anything, they don't create anything. They buy patents out of bankruptcy court, and they sue people for patent infringement. Happens all the time. Phil and I deal with it every day. And trolls are a big problem. But if you have a good defensive IP portfolio, Chris, what do you do when the troll comes a-knocking and you have a good IP portfolio? You're playing poker, and they've showed you their hand. They're suing you. What do? You've got your hand like this. What do? That's exactly right. And when they show a two-pair, you show a full house because you've got a better IP portfolio amassed, and you win. See, that's one of the main things. This is a really interesting phenomenon, this troll phenomenon. Happens every day. And if you want to try it, there are lists of patents for sale on the internet out of bankruptcy courts. You go to the bankruptcy estate, you offer them some cash, you buy the patent, and you go out and hire somebody and you start suing people for patent infringement. Sure. But this is why having an IP portfolio is such a good idea. Okay, now, this is sort of getting ahead of ourselves, but bear with me, it'll all make sense. When you sell your company, and you will, they will send lawyers to come, and they'll sit in a conference room with you, and they'll ask you questions like this. So when you have this exit that we're talking about, when you sell your company for $20 million, the other side will send lawyers, and they'll ask you questions like, schedule all of your intellectual property, write it out on paper, all of it. Prove that you own that intellectual property. Show me how you have protected that intellectual property. Because I'm giving you $2 million or $3 billion. If you can't prove that you've protected it, you see how my value proposition is diluted? Sure, it makes sense. Show me all the contracts you have that affect your intellectual property. And lastly, show me how you have monetized or will monetize your intellectual property. How are you generating revenue from this thing? Show me. Show me the revenue. Show me the contracts. Show me everybody who's paying you monthly paying you money on a monthly basis for a subscription. Show me. This is called due diligence. And this is just 1/100th of the due diligence that they do during a big acquisition, right? This is just a little teeny piece of the IP due diligence. So the goal tonight is to help you all prepare now, today, for an exit. This is the goal. We're preparing you to exit and sell your company for $3 billion to Google. If we do these steps, and they come with their lawyers in their $800 suits, they'll ask you these questions, and you'll be prepared. You'll be ready to go, and they'll write you a check. If we don't do these things, however, it may delay the process. It may undo the deal. It may kill the exit that you're planning on having. Not to be an alarmist, it's just my experience. I've done a lot of due diligence. I'm this guy. I'm the guy. You know that phrase, that guy? I'm that guy. I'm the guy they send in, right? So, and if I don't get the right answers, what will I tell my client? What will I tell my client? Zach, where's Zach? I know Zach is in here because I met him. Zach, what do I tell my client if I don't get the right answers? Not looking good. I don't think we should do the deal, right? Yeah, Zach's right. Okay. So here we go. In my experience, here are the steps that help us prepare for that big exit, the 5 steps. Karen calls it the Frazer formula. Isn't that what you call it, Karen? Karen's one of my clients. Bless her heart, she's here. She calls it the Frazer formula. 5 steps. And you can see that we have, of course, that they are the patent pending 5 steps. And you think I'm joking about that. You actually can't, now Phil, be quiet. You actually can get a patent on a business method. Holly Troxel actually could get a patent on this as a business method. True. Now, it's not, but if I had spent the money and filed a patent application on this process as a business method, we could say patent pending. But we haven't, and I don't have a patent. I just wanted to throw that in because it would make Phil mad, and it would be something fun to talk about. So here are the steps. Number 1, we form an entity. Believe me, we're going to talk about it. Form an entity, identify the IP, own the IP, protect the IP, monetize the IP. Those are the 5 steps. That's going to get you to your exit. If you do those steps religiously with every idea, trust me, you'll have an exit and a big payday, and you will slide through due diligence. Form an entity, identify the IP, own the IP, protect the IP, and monetize the IP. Okay. Number 1, form an entity. A little beyond today's presentation. This is an IP presentation, but it's important. We want to form a limited liability company, LLC, or a corporation, or some other form of entity. Why do we want to do that? There are people in this room for whom we've done this. Why do we want to form an entity instead of just having you own the IP in your own individual capacity? Why? And I'm sorry, I know you're the maker lady, and I've forgotten your name. Jenny, of course. Chris, Kiss, Nis. God, Jenny. Good to see you, Jenny. So why do we form entities? Why? Yes, Jenny. Jenny said, oh, it was who? Anna? Anna, hi, nice to meet you, Anna. It's for protection. Remember the slide with the troll? When the trolls come and sue you, you do not want to be named individually as a defendant. You want your company, your LLC, to be named as a defendant. Number 1, it's because of limited liability. Oh, I actually wrote that on there. Limited liability. So when you get sued, the entity gets sued, not you. And your summer home and call and your Maserati and your 401k all hide behind what's called the corporate veil. And the entity that's sued is the LLC, or the corporation. Hugely important if you're going to play in this space. If you're going to get sued, you've got to have an entity, period. Second, for the exit, Google doesn't want to buy your own personal assets that you've been schlepping around in a briefcase for the past 5 years. They want to buy nice, clean corporate assets, a Delaware C corporation, and with books and records and stuff in file cabinets, and you know what I mean? It's just, trust me, it's easier to exit if you observe this formality and have an entity of some kind. LLC corporation, what the normal path here, what I recommend my clients do in Idaho, we form a $100 Idaho LLC, cheap, easy, do it yourself. Get an operating agreement in place, cheap, easy, probably not do that one yourself. And then you wait. And when it's time to exit, what do? Here's the magic language. We convert you to a Delaware C and you exit. You'll hear that again and again when you meet with the venture capitalists and the angels. They'll say, well, when are you going to convert to a Delaware C? Now you know what that means. That's the entity form that you typically convert to before you exit. But you don't have to do that today. You know, everybody who says, well, you got to form a Delaware C right out of the chute. Untrue. That's not true. Form an Idaho LLC. Form a Nevada LLC. And then we'll convert you to a Delaware C before you exit. That's what 90% of startups do. And it's cheap and easy. Okay, so step 1, form an entity. 2 reasons. Limit your liability. 2, prepare for the exit. Next, identify the IP. Boy, is this important. And I choose to use the metaphor of buckets because it's visual and it's easy to think of. So as you perhaps know, there are 4 kinds of intellectual property. There are patents, trademarks, copyrights, which include domain names and social media, and trade secrets. So let's go through this step. So you have an idea. And let's see, I got a few names before we came in. I won't pick on Jody because he's got to leave in a minute. I'm going to go with Sean. Sean, right, Sean? Yeah. Sean. So Sean has an idea, and he's meeting with his business partners. And they remember this presentation, and they go form an Idaho LLC for $100. What are you calling your LLC, Sean? Do you have an idea? Genius. It's genius. Sean understands intuitively that it doesn't matter what you call your LLC. Call it whatever you want. Just form one. Call it Sean LLC. So Sean LLC meets with the members of his LLC, And they remember step 2, and they say, Brad says we next have to identify the IP. But Sean says, wait a minute, we don't have any IP. That's invariably what clients say at step 2. I don't have any IP. Well, sure you do. You have a ton of IP. You have a lot of it right now. This is the process. This is the exercise, Sean. You and your partner sit down and you start putting stuff in buckets. And sometimes I have literally sat in a conference room with clients with 6x4 cards, and we have literally populated the 4 buckets physically. We can do it mentally, but it's an important exercise because it forces you to identify the IP, step 2. So how do we do that? Well, we have to know what these things are before we can populate the buckets, right? So let's go through them one at a time. First of all, we're trying to identify what patents are so we can populate, remember, 4 buckets. What are patents? Well, unless you're unusual, you do not actually have any issued United States or foreign patents, letters patent from the United States Patent Office. But what we're really doing is populating it with stuff like this: inventions, formulas, know-how, trade secrets. Yes, they go in 2 buckets: patents, if you have any, patent applications, if you have any, software flowcharts, business processes, and so on. Those are the things that go in the first bucket. Sean, do you have any of those? Do you have any ideas for inventions? Well, you must, because you have a business, right? So what is your business? I'm going to write an app that does X. X goes in the patent bucket. Does that make sense? So what is your idea? I'm going to have a mobile dog wash. Idea, mobile dog wash goes in the patent bucket. That's what goes in that bucket. Know-how, inventions, business processes, formula, flowcharts, recipes, stuff like that goes in the patent bucket. And it's an ongoing process. We do it one time to sort of establish the base layer, Nathan, but then we do it continuously because this is an ongoing process. All right, so what are patents? Notice the key word, and I've tried to put keys on every slide. What is a patent? If you actually get an issued United States patent because you've taken some of these things and you've turned them into patents, which you can, what it allows you to do, it permits you to stop other people from doing the thing. That's all a patent is. It lets you stop them. How do you stop someone from doing your thing once you have a patent? Do they just stop? Chris, what do you have to do? You got to sue them. So once you have an issued patent, the patent permits you to stop. Here's the actual definition. Phil, stop me. Allison is also here. She's another of our patent attorneys, Allison Parker. Hi, Allison. Here's a patent. When you have an issued patent for the period of 20 years from the date you file that patent application, you were the only one in the United States, because they're limited to the jurisdiction of issuance, right? The only one who may make, use, sell, offer for sale, or import the patented article for a period of 20 years. That's a huge hammer, right? A patent is a big deal. If you get one, you take that patent and you just go with a microscope and you look around at all the infringers and you say, this guy's infringing. You send him a letter and you make him stop. Normally, they will stop and do what? What do they do so that you don't sue them? Who said it? Well, yes, your letter will be a cease and desist letter, but that's very good. But what will they do so you don't have to sue them? What will they do instead? They will pay you money. Aha, see, it all begins to make sense now. They pay you money so that you don't sue them for patent infringement. And we've already now started to monetize your intellectual property. You get that patent, the stuff that's in bucket 1, you get a patent on it, you go out and you look for infringers because you can stop people from making, using, or selling the patented article for a period of 20 years. That's a long time, right? And you send them a letter and you say, cease and desist, or I will sue you. And instead of that, they say, we don't want to get sued. It's cheaper for us to take a license and pay you money. I used to work at Micron. I got a letter a day from some guy asserting that the screws holding our the computer manufacturer, a letter that said the screws that hold our hard drives in were patented. You're infringing. The hard drives that you're using are patented. You're infringing. The mice that you're shipping are patented. You're infringing. Remember, make, use, or sell. It's a big deal. I got one letter, well, not a day, but a week. So as a business person, I would sit there and I would say, which is better? To defend this thing and engage in $1 million litigation, or pay them 50 cents per computer for a license. Does everybody follow the economics of that situation? See, so people are incented to take a license and pay you rather than be sued. That's the strength of a patent. It's just economics, right? Does everybody follow that? It makes sense, right? You don't want to get sued, so instead, Jordan, somebody will take a nominal license, 50 cents a piece, right? That's nothing when your sales price, your price point is what, $200? 50 cents, you just pass it on to the consumers, and you're done. Okay. So that's what a patent is. It's a piece of paper issued by the United States Patent and Trademark Office, if you get one, that says your thing, your invention, your formula, your know-how, your thing, You are the only one to be able to do this. And the test for whether you can get a patent on something is whether, and we won't spend a lot of time on this because that's not what we're talking about tonight, but in general, if your thing in that bucket, if you look at it and it's new, useful, and non-obvious, and you hire a really crackerjack patent attorney like Phil or Allison, they'll get you an issued United States patent. And then what do you do with it? What do you do with it, Chris? You monetize it by, you guys are all going to follow, you monetize it by how? Phil is exactly right. You find infringers and you sue them. Or instead of suing them, what happens? They, say it with me, take a license, everybody say it, take a license and pay you 50 cents per unit. See the genius of the model? Right? It's found money, you guys. I'm not kidding, it's found money. Populate the bucket and go. All right, next. Trademarks. Okay, we have to spend a little time on this one because most startups confront this more so probably than patents. But remember what we're doing now. Oh, and remember, I specifically at the top of each slide gave you a place marker so you know where we are. So we're on identify the IP, step 2, and we're talking about trademarks. If we went back a slide, we'd see step 1, or step 2, identify the IP patents, but we've now moved on. So we're now populating our buckets with trademarks. So any of you who've been around me know that my favorite phrase in the whole world is trademark is not a verb. Karen knows this. Trademark is a noun. You don't trademark something. Trademark is binary. It's a noun. It exists in space. You either have a trademark or you don't. So we don't trademark things. A trademark is a noun. We create them through use in commerce. Use in commerce creates trademarks. So somebody in here I know has a live internet connection right now. Let's assume that we as a group come up with a killer domain name called 4:30 Consulting, 4:30 p.m. Consulting. Okay, that's not bad, right? 4:30 because it's 4:30. 4:30 p.m. Consulting. This group of smart people could consult on, holy cow, software design, accounting, finance. I mean, this group could consult on also 4:30 p.m. business consulting. Let's just arbitrarily agree that we're going to do that, okay? We're all partners. We shake hands. We have 4:30 p.m. consulting. So what's, you sitting by Dallas, what's your name? Jesse. Jesse, you have a live internet connection right now? Okay, so Jesse could go out and he could register right now for $8, 430pm.com, 430pmconsulting.com. It's probably available, right? I bet he could, $8 and he's in. How long would it take us on Wix or some other platform to quickly throw up a little website? A couple hours? Maybe 45 minutes, right? Maybe. And as soon as that website goes live with the phrase 4:30 p.m. consulting, it goes live and those services are available for people to consume, guess what has happened? Guess. Who said that? Todd? That's exactly what we've done. Did everybody hear Todd? We have created a trademark. It's not a verb. All you have to do is take something and use it in commerce correctly. That's the test. That's why I highlighted use it in commerce. And once you've done that, you have a trademark. So Sean, does Sean LLC have any trademarks? Do you have a website that advertises any services yet? Oh, well, there you go. So Sean has trademarks. So Sean populates the bucket with what goes in the bucket? Sean, let's review. Logos, we all know what logos are. Word marks, see, this is an example. This is a logo, but if we didn't have the H there and we just had the words literally Holly-Troxel, that would be a word mark. That's the difference. Logo has a design element, word mark just is words. So, logos, word marks, taglines. What's a tagline? Field service made simple. Winston tastes good like a cigarette should. I'm dating myself, but that's... let's see, any other taglines? Sorry? Just do it as a tagline. That goes in the bucket. Sean, do you have any taglines yet? You may not. Not yet, that's all right. But do you have any ideas for taglines? Yes. Sure you do. Say yes. Sure. They go in the bucket. They go in the bucket. Okay? Jingles, colors, wait a minute, colors in the bucket. What? 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 Colors in the bucket. Smells? Smells can't go in a bucket. Are you crazy? Smells can't be trademarks. Are you nuts? Look and feel. What are you talking about, Brad? You've lost it. These things cannot be trademarks. Nike can be a trademark. The golden arches of McDonald's, Karen, can be trademarks. But colors and smells? Yeah, actually. So whatever you have that you want consumers to think of your company when they see that thing is a trademark, and it needs to go in that bucket. So you and your partner, Sean, will spend some time thinking of not only the ones you have, but the ones that you will have. What's our brand strategy? What are our domains? What are our marks going to be, right? What are our taglines, our jingles, our slogans? All that stuff goes in the patent trademark bucket. And yes, domain names go in there too. So if you have domain names, this is the bucket they go in. If you don't have any domain names, that's okay. Put them in the bucket anyway and go get them. They're $8 a piece. some, most. .xxx is $99. I happen to know that because I work in this space. I don't register a lot of .xxx domains. They just happen to be more expensive. I just know that. So does your entire social media presence, hold on, did you think about that? Let's just list together the most popular social media platforms right now. Vine. Did you see the thing on native advertising last night on 2020 or whatever? These 3 kids make 6 figures each doing nothing but shooting 6-second Vine ads for Coke. And they make 6 figures a year. It's called native advertising. Advertising agencies will soon be dead. So we got Vine, Instagram, Pinterest, Facebook, Twitter, LinkedIn, Dallas, the list goes on. Your Google, okay, so the list goes on, right? So populate the bucket with all those and identify your social media platforms that go in that bucket. You should list at least those 5, those 10, at least Facebook, Twitter, Instagram, Vine, and if I said LinkedIn twice, Facebook, Twitter, LinkedIn, Instagram, Pinterest, and Vine. Maybe Etsy, maybe eBay, at least those. Okay. So once you've populated that bucket, remember all we're doing is identifying the IP. That's all we're doing. Put stuff in that bucket. Think creatively. Think of what you're going to be using as part of your brand and stick it in the trademark bucket. Okay, next. Cool. Well, I guess I didn't actually, yeah, I told you what a trademark was, right? Let's give you a couple of examples. A trademark is something that causes consumers to think of you as the source. Here are some examples. When you hear a lion roaring in the context of movies, who do you think of? Well, it's actually MGM, Jody, but that's okay, yeah. Okay, let's do another one. When you see a swoosh in the context of shoes, who do you think of? Okay, that's an easy one. Therefore, the swoosh is a trademark for Nike. That's how it works. Let's do a couple more. When you see the golden arches in the context of hamburgers, you think of? Therefore, the golden arches are a trademark for McDonald's, and so on. When I see the name Silverback in the context of educational constructs, I don't think of gorillas, I think of Jim Lewis's incredible company, Silverback Learning Solutions. It's a trademark that Jim has appropriated. See what I mean? So it's anything that causes consumers to think of you as the source of a good or service. That's what a trademark is, by definition. All right. So where are we now? We are on copyrights. We're now identifying the IP. Again, copyright is not a verb. This is one of my real strong things. Copyright is also a noun. What is a copyright? By definition, let me give you the textbook definition. You ready? A copyright is an incorporeal property right that springs into existence when a sufficiently creative idea is reduced into or onto a tangible medium. Isn't that great? An incorporeal property right that springs into existence when a sufficiently creative idea is reduced into or onto a tangible medium. That's it. Let me give you an example. How many of you have ever taken a photograph with your camera? A selfie, a photograph? Sure. Okay. As soon as you trip the shutter, you create a copyright. It's a noun. Because you've taken an idea, this image floating around in the ether, and you've reduced it to a tangible medium, the computer memory in your camera, or the memory in your camera. You've created a copyright. Chris is creating a copyright right now because he's typing notes. So is Jesse. Jade is creating a copyright if he's typing notes back there. Every day you create hundreds of copyrights. Every email you send, you create a copyright. Did you think about that? So Sean, what goes in do you have anything in the copyright bucket? Holy cow, Sean has all kinds of stuff in the copyright bucket. What goes in Sean's copyright bucket? You've got text, photos, I guess I should have added emails, videos, songs, screenplays, novels, drawings, websites, computer source code. They all go in the copyright bucket because it's not a verb. We don't copyright stuff. We create copyrights by taking an idea and put it into a tangible medium. Test. Do I have a copyright in the words coming out of my mouth right now?
Not tangible.
Very good, Jody Cedric. Not tangible. But Bernie happens to be an expert transcriptionist, and Bernie is writing down every word that comes out of my mouth. Okay, now, has a copyright been created? Copyright's a noun. Has a copyright been created? An idea has been reduced to a tangible medium. Who owns the copyright? Bernie. Not Brad, because it's not tangible. Isn't that crazy? That's why, how many of you saw the movie The Social Network? You have to all watch The Social Network. It's the best, believe it or not, it's the best movie on intellectual property ever made. Doesn't that sound silly? But it is. It's the best movie on intellectual property. Hey, Brett, how are you? Good to see you, man. It's the best movie on intellectual property ever made because Zuckerberg says one thing again and again and again as he's defending the lawsuit from the Winklevoss. What does he say? Among other things, he says that. But what he says from a copyright, he says, I didn't copy a single line of code. He says it again and again. Why does he say that? Because the Winklevi had no case. They couldn't sue him for copyright infringement because he didn't copy a single line of code. It's genius, right? Zuckerberg's a genius. He stole the idea, but he didn't copy a single line of code. And you can't sue him for stealing an idea unless it's patented, or you have a contract, and they didn't, right? So copyright exists when you reduce an idea, source code, to tangible medium. If the Winklevi had written source code, given it to Mark, if Mark had copied the source code, copyright, that would have been copyright infringement, and they could have won that lawsuit. But they didn't. So the Winklevi could have learned, couldn't they have, from steps 2 and 4, identify the IP and protect the IP. But they didn't. Okay, so that's the copyright bucket. Questions about copyright, what it is. Property right, that you all own copyrights. You do. Sean owns probably 50,000 of them right now. Put them in that bucket, Sean. Put them in that bucket. Shameless plug, since this is a copyright slide, this is my book. I invite you all to go down to the short URL that I have there. Write that down, tiny.ce/thecure, and buy my book. Okay, having said that, let me move on. Come on. We're going to do it 40 minutes. I got to have a little something here. Last bucket is trade secrets. So what is a trade secret? You know, the definition of trade secrets always makes me laugh because it's so circular. Are you ready? A trade secret is something that has value because it's a secret. A trade secret is something that has value because it's a secret. So let's think of some examples of trade secrets. There are many famous ones. One that we always use in discussions like this. What's an example of a famous trade secret? The formula for Coke, yes, and? Yeah, very good. So let's review. The formula for Coca-Cola. Does it have value? Think about that for a minute. What if Kroger had the formula for Coke? And when Kroger or Walmart made their knockoff generic soda for 99 cents a six-pack, what if it tasted exactly like Coca-Cola? Would Coca-Cola be decimated? Sure they would. So is there value in the fact that Coca-Cola keeps that formula a secret? Sure. That's why it's the classic example of a trade secret. Formula for Coca-Cola. If everybody had it, there would be no value to the formula, okay? So what goes in the trade secret bucket? Well, we have things like recipes and customer lists and business methods and formulas. You can see that there's some overlap with the patent bucket, but that's okay. Some stuff in the patent bucket you may choose not to file patent applications on. Okay. If they have value, then it's important that you, step 4, protect the IP, which we'll come to. But nonetheless, we're on step 2, identifying the IP. We want to make sure that even if there's overlap with the patent bucket, that's okay. Between those two buckets, you're either going to file patent applications or keep them a trade secret. One of those two things. Questions about trade secrets? You all have, Sean, does your LLC have any trade secrets? You bet. It's got a customer list, I bet you. So what if Sean hires my nephew Phil, and Sean keeps the customer list on the break room refrigerator with a magnet, sticking it to the fridge. Phil comes in and looks at it, goes, interesting. He takes a couple of photos with his camera, thereby creating a copyright. And then he leaves the employment of Sean LLC. He goes out and he starts a competing company the next day. Sean LLC calls me and says, this is trade secret theft. It's misappropriation of a trade secret. My trusted employee, Phil, stole my trade secret customer list. And he's now competing with me. What's the first question I'll ask Sean LLC will be? Exactly. Who said that? That's exactly right. Did you keep it a secret, Sean? And you'll say, well, it was in the break room, but only employees could get there. And, but Sean, what about the guy that delivers the water? What about the guy that fills the soda machine? What about the janitor and the plumber? And Sean, there's this long pause, and Sean realizes that there's nothing he can do because he hasn't kept his trade secrets secret. So when they come to do an exit on his company, and the due diligence lawyers show up in their $800 suits, what are they going to say? Sean, you don't have trade secrets. You blew it, bud. Okay, questions? Yes, Anna.
So what happens in a situation, I own an LLC, I own a business.
Okay.
And, my ingredients have to be posted on what I sell. So then the trade secret is the formula? Is that?
Yeah, you know, the FDA and the FTC are actually pretty good about that, right? They only let you put enough on there that you can comply with their marking and regulatory requirements without divulging your trade secrets. So you're actually okay. So there's a fine line. You don't want to give enough away of your secret sauce on the bottle that people can reverse engineer your formula. I mean, if they buy a bottle of your sauce and actually reverse engineer it with micron electronic spectroscopy or something and figure out the ingredients, that's one thing. And you can't do anything about that, right? But there's a line between divulging a trade secret and complying with an FDA regulation, and you should be fine. They're pretty good about it, actually.
And if I were to have a patent on that ingredient list and see somebody else who sells and calls me with the exact
Good.
How would I know that their formula is not just good
It's a
enough?
very good question. Anna has asked, what if she has a patent on her formula for her lotion? Okay. If she has a patent on the formula for her lotion, she suspects someone is committing patent infringement. She takes her patent and she reads what are called the claims, which describe what is patented. She buys a bottle of the competitor's lotion. You hire an engineer to reverse engineer the competitor's product to see how close it is to your patent. If it's close enough, then you sue them for patent, or you send them a letter first and say you're infringing our patent, and you engage in negotiations, and maybe they'll just simply roll over and take a license, pay you money. If not, then you will litigate it. And the court will determine whether or not that product infringes the allowed claims of the issued patent. And this is a very long and expensive process that courts go through. There's a very specific set of requirements, and you have to prove to the court and to the jury that this has occurred. So those are the steps. You become suspicious, you buy a copy of it, you reverse engineer it to see if it's close. If it is, you send them a letter, try to get some money. If you can't, then you sue them. Those are the steps. That make sense? Yeah, that's the problem, right? You know, not to be cynical, but many times only maybe 1%, Phil, 1% of patent holders actually can successfully assert their patents because it's expensive to do. But it doesn't diminish the value for due diligence. That's what we're talking about here. It does not, because Google has the money, right, Jade? Google has the money. So if you have a sweet patent portfolio and you go, I don't have the money, Anna, to assert these, why are we not distraught? Because Google does, Anna. They'll come in and they'll buy that sweetheart patent that you got, and they'll go out and they'll start suing everybody. That's the point. That makes sense? Google does. Yeah, what's your name?
Zach.
Zach. Another Zach. Go ahead, Zach. 2.
So in the example of Sean's customer list, we posted some pictures.
Yeah. Good. Good use of names. That is a great question. Zach has asked a great question. So in my hypothetical, I said that Phil takes a photo of the trade secret customer list. Phil has created a copyright in that photo. Phil owns the copyright. We all learned this because he took the photo. But something, Zach, has changed that calculus. What has changed the calculus? Phil's relationship to the LLC. Phil was an employee. And when you're an employee, Zach, under what's called the work for hire doctrine, your employer owns the copyrights of works created during the course and scope of your employment. So that's exactly right. Are you in law school? Because that's a pretty good thought, man. So that's exactly what I would tell Sean LLC to do. I would tell him to sue Phil for copyright infringement because we don't have trade secret misappropriation as long as Phil was Sean's employee. That makes sense? And actually, this now segues with the next deck here. Oh, very good, Zach. Own the IP. This is a perfect segue. Well done. All right, so we've talked now about step 1, form the LLC, form the entity, right? Limited liability, exit. Identify the IP, because if you don't identify it, you can't make money off of it. Next step, own the IP. Holy cow, how important is this? I can think of 3 instances where I have gone in to do due diligence on an acquisition target. We were ready to spend money. My company had $300 million in the bank, and we were ready to write checks to companies. I went to Atlanta, I went to LA, I went to Kansas City to do due diligence on these companies. And in each case, when I got to this question, do you own the IP? This was the stopper. This is the one that kills you right here. Because you got to own the IP. And it's a really, really tricky concept. Even if you've done steps 1 and 2 correctly, if you don't own the stuff in the bucket, then when they come to do due diligence on you, this will kill the deal. It just does. All right, let's talk about owning the IP. Long slide, but bear with me. It's challenging because each of the 4 kinds of intellectual property has a different ownership construct. The way Sean's LLC gets ownership of the stuff in the patent bucket is different than the way it gets ownership of the stuff in the copyright bucket and the trademark bucket and the trade secret bucket. It's different. They're different. So you have to be vigilant, Sean and others, to make sure that the LLC, once you've identified the IP in the buckets, you literally will pick up each card and say, who owns this? Who owns it? And if you don't say that the LLC owns it, then you have a problem and you have to fix it. And it's far easier to fix it in advance than it is retroactively to go back. Just this past week, I've been spending time cleaning this up. For a client who doesn't own its IP, and we've been trying to go back now and get the IP vested in the client. And how hard is that when the person who owns the IP is an ex, right? A significant, or someone who's deceased, someone who's moved, a disgruntled former employee. You see the problems, right? So it's far better to be proactive about this. And once you've identified the stuff, step 2, in the buckets, pick up that card and say who owns it. So for example, as a general rule with patents, as a general rule, the inventor owns it, meaning the human being who came up with the idea. So Chris and Jesse form a partnership. They form a business, a little handshake partnership. And Jesse comes up with this idea for the killer app. The LLC files a patent application on it. I go to do the due diligence and I say to the LLC, do you own the invention that you filed the patent application on? And I will ask for a document called an assignment that shows that Jesse contributed or gave this invention to the LLC. And if you don't have that, Chris and Jesse, guess what? Who owns the invention and the patent? Jesse.
Does that apply even as an employee?
Yeah, very good, Jody. The question was, does that apply even as an employee? Let me answer it this way. There is no work for hire doctrine in patent law. That only works in copyright law. The employer can get what are called shop rights. They're called shop rights. So when this happens, you cannot be divested of your right to use the invention under the shop rights doctrine, but you will not own the patent. The employee will. So this is why there's so much litigation about this issue. You know, we seek to invalidate a patent because the named patentee doesn't actually own it. Because, why? Chris, you didn't have Jesse sign an assignment agreement. It's just a simple piece of paper. It's a one-page contract. This says, Jesse, well, let's use Sean. Jesse gives to Sean LLC all of his right, title, and interest into any inventions that he may invent. Done. Sign it, done. Okay, copyrights. As a general rule, the author owns a copyright. Oh, yes, I'm sorry, Chris. Chris. Yes. Yes. As a general rule, some states, Phil, I think where you're going, some states, like California, has a statute that says you have to be very careful about an overexpansive grasp of an assignment clause. Is that what you were going to mention, Phil?
Actually, I was going to say, at least in our case, the employment agreement is going to include a blanket assignment. And in addition, when we file the patent application for you, we're going to require the inventors to fill out an additional assignment with respect to that specific patent. So you have double coverage, both on the blanket
Yeah.
and with the specific invention you're going to file. And that is the way to do it.
So, but to your point, Phil, yes, assignments may be prospective, but some states have laws that say you may not, Mr. Employer, make a land grab. You cannot cause the inventor to divest all rights and everything that, even if it doesn't relate to the work. Some of them say that. They say, I want everything Jesse invents, even after he leaves my employment, even if it doesn't relate to what we did together. Some do say that, right? California has a statute, and other states do as well, that say you cannot do that. But yes, generally speaking, they may be prospective in their application. Yes.
One more question.
Go ahead.
Let's say I come up with the idea, and it's a software solution or something, and I hire somebody else to do the coding for it. Who's the inventor?
It's an excellent question.
The work in or the
And as a general rule, if all you're doing is asking the coder to act as a scrivener and simply code using coding programming language, your ideas, your methodologies, your flowcharts, then you will remain the inventor. Phil has an awesome story that he'll tell you offline about this exact hypothetical. So I will invite you to talk to Phil and ask him to tell you his awesome inventorship story, because it's a good story. But in general, you can engage third parties without causing there to be a problem under patent law, as long as they're a mere scrivener. Copyright, though, Chris, is different, as we've now learned. Same hypothetical. You go to a guy and you tell him to write source code, right? He may not be an inventor under patent law, but he may be the author under copyright law, right? Because he's the human being, he's writing the code, he's creating the copyright, so you've got to get the copyright as well. And I know that's an involved concept, but I mean, that's the issue. All right, so as a general rule, to your point, Chris, the author owns the copyright in the code. And so you need to get a written assignment. This is the one law that is very specific. Copyright law says you need a written assignment signed by the author, in order to divest the author of the copyright and transfer it to the LLC. This is why, have you ever worked at a big company like Intel or Micron or HP? You work at Micron. I knew that because you told me that. So during orientation, they had you sign a document called General Assignment of Inventions and Rights. This is why. So when you go, I've been ignoring this side, forgive me you guys, Chris is asking all the questions. So when you go to work for a big company or a small company, they may ask you to sign a document called General Assignment of Inventions and Rights. This is why. Because they're trying to implement step 3, own the IP. And so it'll be very broad. It'll cover patents and copyrights and everything, a general assignment of inventions and rights. But you can also make it very specific and limit it to copyrights as well. So remember, where are we? We're owning the IP. We want the LLC to own the intellectual property. Trademarks. As a general rule, the user of the trademark owns it. Now, sometimes this is frustrating and complex because it's sometimes tricky to determine who the actual user is. For example, if Sean allows Todd to sell his products, okay? Sean makes tennis shoes. Sean LLC makes tennis shoes, and you have a great trademark of shoes. 3 lines that don't infringe on the Adidas mark, okay? You allow Todd to use those 3 lines to sell his brand of shoes. And there's no paper underlying that. There's no license agreement. There's no understanding. Even though you think you may own the mark and you just have allowed Todd with a handshake to use it, guess who's acquiring trademark rights? Todd. So it's sometimes, and so thus, if you were going to solve this problem, Sean, and get the trademark back from Todd, you would have to have him sign a piece of paper giving back to the LLC all of the trademark rights. See, so again, we're repeating the same test. Look in the bucket and ask the question, who owns it? What about domain names? For example, let's assume you work in a big company, right? And the IT department is given free rein to go register domain names. And you go and you do a multiple who is lookup. We do these as part of due diligence. We get a list of all the domain names owned by the company, right? And I can't tell you, 90% of the time we have Ed in IT, Susan in IT, Fred in marketing, Carlos in IT have registered domain names. And the company does not own them. Or somebody in marketing, bless their heart, they'll go out and they'll get your Facebook page for you or their Twitter handle. You see the problem? It just multiplies when the LLC doesn't get its hands around this thing in the beginning and get a hold of all this stuff up front. It's far easier to get it in advance than it is to go back and get it. Lastly, as a general rule, the inventor or author owns the trade secret. In Sean's case, the person who came up with a customer list, as long as it's kept secret. On such facts, you need an assignment. What's the common word in all 4 of those? So what's the moral for the LLC? Here's the way I say it. Yeah, please, go ahead.
So along those lines, if you have an LLC and the members of the LLC, maybe, I have a situation maybe where it's not clear who is the inventor of a concept or an idea.
Right, good.
As members, we just brainstormed it, came up with it together.
Right.
As members. Is that true? Can an LLC be the inventor?
Absolutely. Well, actually, the inventor will remain the human being. The LLC becomes the assignee, it's called. And so those are the terms of art that we use. The human being is always the inventor, but the person to whom the inventor gives the rights is called the assignee. And to answer your question, absolutely. Once the LLC has looked in the patent bucket, it will ask, well, who owns that? And if you look around the table and it's Ed, who bought the pizza that night, and that's his contribution, you need to get Ed to sign one of these documents. So let's make it simple. The common theme here is assignment, all right? So at step 1, form that LLC. Step 2, identify your IP. Step 3, look in the bucket, and every human being who has authored or invented or created something in the bucket, what do? You get them to sign an assignment. And it's a lot easier to do that in advance than retrospectively. So we make it, what is your name? Eric? Aaron. Aaron, we make that part of our startup package for a startup LLC. You form the LLC, you get an operating agreement, we give you a non-disclosure agreement because that protects your trade secrets, and we give you an assignment, a general assignment of inventions and rights. And what I say to you, Eric, is this. Aaron, I say, Aaron, everyone who creatively contributes to the product must sign one of these. See how that covers patents and trade secrets and copyrights? Just do it. So yeah, it's arduous because you got to get every photographer, everybody that wrote lines of code, everybody that created your website, everybody who came up with an idea. Yeah, you do. Well, you don't have to. But what's the point? The point is that we're trying to, what, prepare you for an exit. That's the goal here. Yeah, Chris. Yeah, everybody signs it. It's a good question. Let me be clear about this. The fact that you're a member of an LLC does not inherently transfer ownership to the LLC. Membership is not an assignment of IP. Just because you're the CEO of a company, the LLC doesn't automatically own the IP. The only time that works is with the employer-employee relationship, and you guys all know that only works with what now? Copyright. That's very good, whoever said that. Copyright. That's the only one that has a work for hire doctrine. So that's why, Aaron, the packet that we give, everybody signs an assignment. And sometimes it's uncomfortable because you got to go to your brother-in-law and say, hey dude, you drew this logo for us. I need you to sign one of these. And what if he doesn't want to sign? Let's ask that question. What if the principal contributors to your IP does not want to sign an assignment? What do you do? What do you do? You either wait for that horrible hard question to be asked at due diligence, at close, and they walk away, or you take that IP out of the calculus, right? You take another photo. You rewrite the code. And Chris is going, Brad, it's 1,000,000 lines of code. I can't rewrite 1,000,000 lines of code. I know. But see, there are solutions. If you cannot get an assignment retroactively, you need to take the IP out of the calculus. That's what you do. That's the brute force solution to the problem. Okay, own the IP. All right, we're making good headway here. This is awesome. All right, next let's talk about protecting the intellectual property. So we've formed our LLC. We have identified our IP by populating the 4 buckets. We have obtained ownership of the IP, and now it's easy, in air quotes, for the LLC to go back and protect this IP. Why do we want to protect the IP? Can't we just stop at step 3 and list all this stuff on our balance sheet as an intangible asset and wait for our close, wait for our exit? Why do we have to do step 4? And it's not to make money for lawyers, although, yes, this is where lawyers make most of our money, is step 4. I'll admit it. You don't have to do step 4. Why do I strongly recommend that you do step 4? Think back to Econ 101. Think of what's called the supply and demand curve. What happens when you restrict the supply of a commodity? Jody Cedric says correctly, the price goes up. When you restrict the supply of a commodity, the price goes up. When you have a patent on the only way of doing something, what have you done? Econ 101, what have you done? Because a patent permits you to stop other people. Chris, Zach, you turn off the spigot. What has that done? What does that do? It constrains the supply, right? Econ 101. So what happens to the price you can charge? What's a cartel? Anybody know what OPEC is? Right? What's their magic mechanism that permits all of them to have $8 billion mansions in the middle of the desert? It's supply and demand. They just turn off the spigot. How do you, sitting in Boise, Idaho, turn off the spigot? Step 4. That's how you do it. Because otherwise, I will take your IP with impunity and laugh at you. Right? Absolutely. If I know what I'm doing, in fact, there's a slide here. Well, we'll wait, and I'll show you the slide. And I think it makes my point better than I can make. So step 4 is important because, oh, look at that. Why? Why do cartels make money? It assumes the entity owns it, of course. Step 3, if you don't own it, you can't protect it. Step 4, so the IP in each bucket is protected in different ways. Is everybody on board with the necessity of protecting it? Does everybody agree? Some of you are saying, but wait a minute, I don't want to do that. That's draconian. I don't want to protect my IP. I have an open source mentality. Everybody remember my initial slide? What's one of my assumptions? There's no open source guys in this room. We all want to make some money. And if that's true, the way we do it is we constrain the supply by protecting the IP. And if you're open source, that's fine. That's terrific. This construct assumes you're in it to make some money. Okay. So how do we protect patents? Once you've identified the stuff in the patent bucket, the general answer is you file a patent application. Here are the keys. Timely application and enforcement on issuance. Timely patent application and enforcement on issuance. There are really, really important timelines that I won't delineate. Phil or Allison can delineate if you want to track them down afterwards, about when you file a patent application. In general, generally speaking, and I'll ask them to correct me if I'm wrong, because I'm not a patent attorney. I'm a non-patent IP lawyer. I rely on these guys for the heavy lifting and moving on patents. In general, in the United States, because of what's called the America Invents Act, you have 1 year from the date of first disclosure to file a patent application in the United States. And the United States is now a first-to-file patent jurisdiction joining the rest of the world. Meaning that, in general, the first inventor to file is the one who ends up with the patent. First inventor to file. And so it's kind of a race to the courthouse. You want to be the first one to file that patent application, first inventor to file, and you want to file within 1 year of the date of first disclosure of that invention, or you will have lost those rights in the United States. Other countries are not so forgiving. Foreign countries do not have a 1 year grace period. So if you've made a public disclosure of the invention, you probably cannot get patent protection in foreign countries. Now, 20 years ago, we would have said, so what? But because of the internet, it's changed all those paradigms. Every one of you will have an international presence. You just inherently will. You'll all sell your stuff in foreign countries. So timely application and enforcement on issuance, meaning the stuff we've already talked about, Anna, you sue them. That's what I mean. Okay, Chris? Wow, that's a whole long subject. Phil, do you have, like, can you do that in 1 minute? Like, what's a disclosure?
3 areas you can shoot yourself in the foot. Public disclosure, that's what pretty much people understand that on its face. You go out and talk about it too much, you show it to too many people. Once you do that, you got a year to get on file. Public use, it's not so much what you see on its face. The thing you got to be careful of with public use is that just because the public can't see it, for instance, transistor deeply embedded in microprocessor, deeply embedded in the system, because they can't see it doesn't mean it's not a public use. It's being used the way it's meant to be used, regardless of whether the public can see it or not. Do that, you got a year to get on file. The last one is an offer for sale. On offer for sale, the trick is you don't have to have a working prototype. What the court does is if I offered Brad to sell him this pen today, no, not this pen, but one that I'm bringing up, like it,
Right.
what the court's going to do is they're going to freeze frame right when I made that offer, and they're going to say, if I turned around and talked to myself and said, can you file a patent application, and I could give myself enough information to file it, that's considered a legitimate offer for sale regardless of what I have in tangible form. So those are your 3 ways to shoot yourself in the foot. Any nuances on that?
That's good, Phil. Yeah, thanks for that. And for those of you online, basically the 3 issues, the 3 areas that will create a public disclosure triggering that 1-year thing in the United States: public disclosure, public use, offer for sale. Just be extraordinarily cautious about those 3 things. When I was at Micron, our marketing people would always go to trade shows. And the first question the legal department would ask them is what? We're off to a trade show with new products. What's the question? Going to a trade show, new products. Are you going to file any patent applications on this stuff? See why that would be a critical question? Let's make sure everybody understands, why is that a critical question? Because at the moment they go to the trade show and they show it to a vendor or a customer, that's public disclosure. Actually, even though it's, to Phil's point, it's not on display, but it's in the thing, right? So we would be overly cautious and we would make sure that we were on file within that year period of time. Or alternatively, if we were going to do international filings, what would we do? We literally do this. What would we do if we were going to make international filings? Knowing that if we hadn't made our international filings before the public disclosure, no patents for us in France, what would we do instead then? Think hard. What would we do? Yeah, who said that? Who? Todd is right. Not show it. Or more appropriately, because it's a trade show, Todd, you got to show it. We literally had everybody that went into the booth sign a non-disclosure agreement. Right? No public disclosure. So it's really, really critical. Yeah.
Hard to wait until 2 days before the disclosure. You call it the patent attorney and make him lose sleep before you put that out.
Well, there's that.
That is actually the more common.
Yeah, there is that. Phil's exactly right. We had, yeah, it would be. That would, Jody's right. It would be an expensive call. So, you know, I mean, that's sometimes what happens, right? You have to get on file before you make one of those 3 kinds of public disclosures, Chris. So very good. All right, so timely application, can't overstate that. It's so important. And enforcement on issuance. If you don't have to enforce your patents. I mean, they last for 20 years from the date you file a patent application. If you get one, you can hang it on the wall in your den. You don't have to enforce it. But I think it helps because once you have that first successful enforcement under your belt, what happens to the rest of the infringers out there? They fall in line, right? So Anna goes out and sues defendant A for patent infringement and wins. Suddenly there's an Idaho federal court decision saying that Anna's patent is valid and infringed. What does Anna immediately do? She sends letters to the next 10 infringers and says, guess what, kids? Patent valid, opinion of infringement, and your product is identical to the product of defendant A. Pay up. See? That makes sense? That's why it's so important, if you have them, to be vigilant in your enforcement. But you're going to say, I don't have the money to assert it. But Anna, who does? Google does. Right. That's exactly right. Okay. So what about patent pending? Well, one of the things to know about patents is that they are not effective until they issue. They have to issue. So although we append, we put patent pending like I did on my slide. We put patent pending on there. What it really means is that there has been a filed patent application, and if you infringe on this thing, 3 years from now when my patent issues, I'm going to sue you. It's basically just a barking dog in the front yard, right? It's a warning, isn't it, that you have filed a patent application. So it's relatively cheap protection. You're putting the world on notice that you have filed a patent, well, the US, that you filed a patent application, and when it issues, I'm going to sue you. So tread carefully. Yeah?
Since we all want to make
Right.
Since that we would enforce it, but I also heard the analogy that it's a lot like having an inroad on your land. The neighbor uses it every day.
Oh.
As well, that with patents and copyrights, if you choose not to enforce them, then you also create a history of showing that you don't want to enforce them. So
Yeah.
10 years from now, if you decide to enforce it, you can say, well, you
That's
were
good.
enforcing it all this time.
That's very good. What is your name?
Andrew?
Andrew, that's very good, Andrew. Andrew makes the point that if you don't enforce a right, you lose it. If you allow someone to trespass across your land for 20 years to get to the well, and suddenly you shut them off from getting to the well, you can't do that. You can't sue them for trespass because they have a right that's called adverse possession. No, there's a right that you get. It's something like that. An easement. There you go, Phil. Thank you. An easement, right? So, is there? Yes. The answer is yes. There's something analogous to that. They're called laches and estoppel. L-A-C-H-E-S and estoppel. E-S-T-O-P-P-E-L. Those are defenses the defendant will assert. But, Andrew, it assumes that you were aware of the infringement. So if you are aware of, and there's also something called a statute of limitations, right? So there are three things that can go against you. Statute of limitations, laches, and estoppel. So if you're aware of the infringing activity and you do nothing, then when you ultimately choose to sue, the defendant will assert statute of limitations. It's 3 years for copyright. There is no statute for trademark. What's the statute on patent? Is it 3? Anybody know? Maybe is it just laches? Just laches. So 3 years to sue for copyright, and the other two are just equitable. You know, sue. So Andrew, that's why again I maintain important, because once you're on notice, my friend, you got to do something, because eventually laches, estoppel, and the statute are going to bite you and render that IP without value as to that defendant, right? Okay. Great. Yeah, go ahead,
I
Phil.
just don't want you to walk away with your own idea. It has to be very specific knowledge of somebody specifically infringing your patent. It's, you know, the idea that just because you sit on a patent, you're not really tracking who's using it. You haven't lost any rights there. You have to be really aware. And what that is protect somebody that's tooling up, and they're putting a lot of investment into this, and then all of a sudden you kind of come up like a submarine and nail. The law doesn't want that. But you don't have to assert your patents to get those rights. It's just you become aware of specific.
Yeah.
I just want to make sure.
No, that's great. That's important. Yeah, it's a
Asked to see if that was kind of an urban legend.
no. It's a notice. To Phil's point, Andrew, it's a notice issue. When you're on notice and the right form of notice, then you do need to act. Jordan, did you have a question? I saw a hand. Yeah, go ahead. Chris.
Yeah. I was just wondering, as far as exclusive rights, is it from the time of the actual registration or the time of the approval?
With patents, your name just went away, and I'm usually very good at it. Chris? Another Chris. That's why. See, I'm thinking of this Chris. Chris. With patents, the patent is effective when it issues. Trademarks and copyrights are different. That's why it's tricky. But patents are, you may sue somebody for patent infringement when the patent issues. That's why there's this term like submarine patents and other things. You file your patent application and then you wait. And you allow people to infringe, and you hope people infringe. And that's why you want a very broad foundational patent, right, that covers a lot of stuff. If you get one of those, to Anna's point, right, you get one of these really broad foundational patents, then you just wait. And you line up the infringers, right? And then as soon as your patent issues, bada bing, you just knock them off one by one.
That's why everyone goes to market early.
Right. Because, Chris, what Chris has said is exactly right. Let's spin it on its head. Let's assume you're not the enforcer, you're the infringer. Chris wants to infringe on Sean's patent. Chris sees patent pending on the thing. What does Chris do? In fact, I can't believe I didn't tell this joke. What does patent pending mean? It means copy it quick. Right? Because you may literally infringe with impunity until the patent issues. And all you have to do is stop before the patent issues. You can't go back and sue somebody for pre-issuance infringement. It doesn't work. You can sue them for, that's why I'm such a fan of the Gestaltic patent, or the Gestaltic IP portfolio, right? All four, because patent, there's that limitation. But what do? Just like Sean sued Phil for copyright infringement, we haul out some other arrow out of our quiver and sue him for something else while we're waiting for the patent to issue.
Well, so then why would you even bother putting patent pending on your product? I guess maybe I'm missing, you legally have to do that once you file a patent.
You do not legally have to. Phil was chomping at the bit to answer this, but let me try. You put patent pending on because, number one, it acts as a form of notice that you've at least filed a patent application. But there's also, Anna, a marketing reason. In general, do consumers react more favorably to something that says patent pending or not? In general. In general, do you react more favorably when you see the words patent pending on something? Why? because you think it means something. You think it means, well, we can all be honest, we think it means it's been endorsed by the federal government, or it's a good thing, or some federal scientist has approved it, it's patent pending. So there is a very cynical and real marketing reason to file a patent application. You put patent pending on it, because you'll sell more stuff with patent pending on it than if not. You see my point? It's very cynical, but it's true. So okay, Phil, do you want to, this is the cynical answer.
Willful versus non-willful, you can get some of the notice requirement in that.
Okay.
That's a whole different thing. I mean, when you have to talk to the
Yeah. Okay. Aaron?
So, along these lines, is there any guarantee that the pending patent is going to go through?
No.
Infringe on it, maybe they can write this, but maybe the patent will not go.
No, see that. So what you do then is you file your patent application, slap patent pending on the side, and sell as many of them as you can, as fast as you can, before a bigger, stronger competitor comes along and steals your IP with impunity. Right? That's exactly what you do. That's why it's so important to have done all this stuff, hopefully in advance, retroactively, so that when that happens, you can at least extract some value from the IP. Now, Aaron, to your point, you don't have to do any of this stuff. We've talked about that. You could just hit the ground running, sell as much of the stuff as you can, and get out before a competitor comes along. That's in my view, that's sort of a short-sighted strategy. My view is it's better to prepare for the exit, which is the theme of tonight's presentation, right? Yes, Elizabeth. Yes. The question was, does the date of your patent application protect you? Sort of. It doesn't. The mere date doesn't give you a preclusive effect, but what it does is establish your priority date, which is important in terms of establishing potentially inventorship, and it helps you with foreign filings. And first to file. Thank you, Phil. So, because remember, now the U.S. is a first to file patent jurisdiction. So if Sean and Phil race to the patent office, and they're both inventors, the first inventor to file will get the patent as a general rule, first to file. Yes?
How could a bigger company come by and keep you out of your patent if it's already pending?
Well, the question was, how can a larger company come and kick you out of your patent if it's already pending? They won't. What they'll do is they'll steal your technology and use it with impunity until your patent issues, and then they'll see that you don't have the money to enforce it. So they'll continue to infringe until Google comes along and buys you, and then they can make them stop. So you're right. The protection here that we're getting is only as good as your bank, your wallet, right? But remember, we're talking about preparing for an exit. Assertion is just one aspect of monetization, right? Let me say it again. Assertion is only one aspect of monetization. You don't ever have to assert that patent. If it's a great patent, you'll still get a payday because Google's going to buy it, right? Okay. Okay, trademarks. Wow. So you have, oh, please, Zach. Too many Zachs and Chris's. What is it with the Zachs and the Chris's tonight? Zach, go ahead.
So kind of back to the instance where you don't disclose that you filed the patent. Could there be any implications on, so if I essentially copyright you without having known that you filed the patent, and then once it's issued immediately you come back, there are any like fact-based implications if you come back and see?
No. No, in fact, unlike copyright, there is no defense under patent law for what's called independent inventorship. So if you innocently infringe and you invent the exact same thing in your garage, and I get the patent first, and you have no idea I even exist, and you've never seen patent pending on my stuff, as soon as my patent issues, I can sue you for patent infringement. And you have no defense based on you were unaware of the original invention. That's different from copyright and trademark law. So again, another difference, right? So, but now let's move on and talk about, remember, here we are in our rubric here. We are on protecting the IP, step 4, and we're talking about trademarks. So a client will call and say, I have a great idea. Thanks for coming, Todd. Oh, and by the way, some of you have to leave because of a conflicting event at 6 p.m. So if you do need to leave, please step out, and we'll wish you a good luck and bid you adieu. And if you have any follow-up questions, my contact information is on most of the slides. I'm happy to send you a copy of the deck as a PDF if you wish, or I'm happy to visit with you on the phone. So if you do need to leave because of that conflicting event, please feel free.
But before you do, please fill out the survey.
Thank you, Sheila. All right, so now let's talk about a different kind of IP. We've talked a lot about patents, and it's a fascinating topic. I really do encourage you to follow up with Phil or Allison because it's a very specialized topic. But remember, our theme tonight is to give you general awareness of this so you can populate the bucket, protect it, and exit. And when you get to that point and you need to protect it, you call a patent attorney, typically. You can do it yourself, but you typically would call a patent attorney. All right, so let's talk about trademarks. Clients will call me, bless their hearts, and they will say, Brad, I need to trademark this. Now, let's pause for a moment. What's the first thing that I will say to them? Oh, it's excellent. I'm so pleased that you all said that. You should say that resoundingly. Trademark is not a verb, you will say. It's a noun. Trademark is a noun. But more importantly, there's more to it than just trademarking something. In my experience, there are 3 pre-launch questions that precede any brand launch. And these, you guys, these are critical. All 3 of them are critical. Here they are. Number 1, can you use the mark or the brand without getting sued and losing? Number 2, can I register the mark with the United States Patent and Trademark Office? And 3, have I secured the social media space that surrounds that domain or that mark? If you can't answer all 3 of those questions yes, then I will recommend you do not launch with that brand because these will impair the value proposition for your exit. Let's go through the hypotheticals. Can I use the mark without getting sued and losing? That's a very specific inquiry, and it has nothing to do with filing a piece of paper with the trademark office. Completely different. Sure, you can trademark something by filing a piece of paper with the trademark office. Sure you can. You can go to uspto.gov. Jesse, right now, from that computer, could go to uspto.gov, file a trademark registration application on 4:30 p.m. consulting. He could do it. $325, he's in and done, right? He could do it. But that's like one-tenth of the equation, right? The better question is, can we use 4:30 p.m. consulting without getting sued and losing? It's a completely different inquiry. Here's the test. Has someone in the United States, or frankly, if you can, anywhere in the world, used a similar mark on a related line of goods and services before you did? Trademark law, first in time is first in right. First in time is first in right. Whoever uses the mark first, in most cases, will win a trademark dispute. Use is key. That's why the first question is, can I use the mark without getting sued and losing? And how do we answer that question? Well, we do a trademark search. And we look to see if anybody has been using the mark in a related line of goods and services before you were. And if they have been, then it's my practice to opine to the client and say, I cannot opine on whether you're going to get sued. I have no way of knowing if you're going to get sued, right? I don't know that. What I can do is opine, but just based on experience, if you do get sued, what are the odds you're going to win? You guys are all entrepreneurs, right? So, and I'll say to Dallas, Dallas, if you start using this mark and you get sued, there's a 60% chance if you get sued, you're going to lose, okay? Confronted with that information, what does Dallas do, or Sean, or any of you are entrepreneurs, what do you do with your go, no-go brand launch decision? Do you proceed? I don't know. It's your decision. My job is not to make your decisions. I'm your lawyer. And I will simply say to you, if you proceed, Karen, there's a 60% chance you'll lose this lawsuit if you get sued for trademark infringement. And the tests are very standard. They're easy to apply. Were they using it first? Are the marks similar? Are they related lines of goods and services? How much money do they have? How much money do you have? I mean, you just throw it in the pot and come up with 60%. And in my opinion, I do not recommend that a client launches without being able to answer number 1, yes. In the computer industry, this was called shipping with a known defect. Shipping with a known defect, right? I get a Friday afternoon at 5:30, I get a call from product development, I guess it was, and I was summoned to this emergency meeting back in the bowels of the manufacturing division. And they sat me down and they said, this is an attorney-client privilege conversation, right? And I said, yeah. And they're defunct, so it's okay. And I said, what's up? And they said, well, we have an order for 50,000 computers. But we just discovered 10 minutes ago that the hard drives are defective. Instead of being 1 gig hard drives, they're like 850 megabyte hard drives. We're shipping with a known defect. That's the same thing. Well, what do you do? And I said, well, I'm your lawyer. If you ship these, we'll get sued by the Federal Trade Commission for false advertising, and we'll also get sued by the purchasers for a breach of warranty and false advertising. It's your call now. I've told you the legal risks. Same thing for you. If I opine there's a 60% chance you're going to lose, it's the same thing. Do you as an entrepreneur proceed in the face of a known risk? And I think that's all I can say. There it is, right? So I want you to be able to say, yeah, I can use the mark without getting sued and losing. And if I come back with a number that's like there's only a 20% chance you're going to lose, that's a pretty good number. I would go. That would be, for me, I would go. If my lawyer said, yeah, there's only a 20% chance you're going to lose. That's an acceptable risk as an entrepreneur. Particularly because you followed, what? Step 1. So when you get sued, who's the defendant in that trademark infringement lawsuit? The LLC. There you see how it all comes together at some point here? Yeah, Chris?
No, that.
Oh, you're just
I was gonna answer
exulting. You just, oh, you had an epiphany, right, as to why you formed the LLC, right? Yeah.
So,
Anna.
say you launch your company, what happened to me, what I'm with right now, launched a company under a name that I thought was unique to my business. Come to find out there's a trademark out on that name from a company in the UK.
Oh.
And so I'm in the process of renaming my company. Once I have a trademark on the name that I'm renaming or moving to, can they retroactively sue me for the product
Yes.
so far?
Yes, they can. Anna said, I'm currently infringing, but I'm changing my name. Can I still be sued after I change my name? Yes. Can you lose? Yes. They can get money damages for the past bad acts of infringement. Yes. Assuming that they have a valid trademark in the United States and that the marks are confusingly similar. That's the test.
Their trademark was lapsed when I launched my company. I don't know if that was
You know, Anna makes an interesting point. She says their trademark was lapsed. Remember, kids, trademarks arise through use, not through registration. So sometimes clients, bless their hearts, will go out to uspto.gov and they'll do a search and they'll say, oh, well, Brad, these are all dead. They're dead at USPTO. And what do I say to them? That doesn't matter. What registration is irrelevant to the calculus. We're not on question 2, we're on question 1. Trademark rights arise through use, not registration. I guarantee, Sean, that right now, if we were to do a trademark search on your brand name, we would find 20 potential plaintiffs out there who are going to sue you, none of whom have registrations at the United States Patent and Trademark Office, because trademarks arise through use, not registration. Question 1. Do you see why they're different? Trademark rights arise through use, not registration. Question 1. Can you use the mark without getting sued and losing by a prior user? Does everybody understand that? It's critical. I don't know how else to say it. USPTO.gov is not the answer. That's number 2. 1 is, are you going to get sued by a prior user, Anna?
But they can only sue me up to the point that I was using that name. Once I change, then whatever
Right.
I make after that.
Well, generally speaking, yes. Assuming that you're not still infringing, yes. But what you will get is what's called an injunction, which is a court order compelling you to stop ever infringing again, so you can't go back to the old name. Otherwise, you'll be in contempt of court. Okay. All right, good. Does everybody understand that? It's really important. Can you use the mark without getting sued and losing? It's almost the most important of the 3. Zach. Right. Well, were they using it first? Are you in a related line of goods and services? Is the mark confusingly similar? Oh, there you go. So so that's the analysis. If you get sued, it sounds to me like there's a 70% chance you'd lose that lawsuit. Zach, there you go.
So can we have them assign the name?
Sure. We do that all the time. We buy trademarks all the time. In fact, what does Apple do when Apple finds out it can't get the trademark that it wants? What does it do? It buys the company. It doesn't care. Right? It finds a little company in Mexico that's got I something. Well, they just go buy it for $50 million. That's a whole lot easier, isn't it, than interrupting their entire I brand strategy? Of course it is. Yeah, Andrew.
Something I want to touch on though, because I hope that it ties all these ideas together. Since I help folks with their marketing and branding, you mentioned, is it related lines of goods and services? Are they confusing or similar?
And prior use.
And prior use, yeah, because if I want to have Coke heating and air conditioning, and I don't use red colors primarily,
Right.
I'm not necessarily the same kind of. So you can call it whatever you want to, mostly. Just so long as these other points, I'm not using their smell or their color or their. How many people go to Vistaprint and go get a swoosh for their logo?
Uh-huh.
So that's okay, so long as,
Well, no.
no,
I cannot opine that it is okay,
so,
because you've picked two that are what are called famous marks. The swoosh and Coke are famous. And famous marks, they don't have to be confusingly similar. If you're diluting or trying to simply capitalize on the strength of a famous mark, we throw confusing similarity out of the calculus. Yeah, you're just trying to capitalize on the strength of it. Why else would you have picked that mark? You just didn't wake up in the middle of the night and think, Coke, right? Nike, I'm going to call my thing Nike. I use the man from Mars test, Andrew. If the man from Mars doesn't know what your thing is, it's probably a good trademark, right? There you go. Sure. All right, Aaron.
So, similar to that question, I guess, maybe just kind of an application that I've always done that shows complexity. It's the Boise Fry Company.
Oh, yeah.
Idaho Fry Company.
Yeah.
And I don't know if you're part of that.
I was a little bit, yeah. But I can talk about it.
Okay. So that ended up being trademark infringement with the Idaho Potato Commission, right?
Yep.
Because fries are making potatoes.
You know, Aaron, that was never litigated, right?
It wasn't.
So was it infringement?
No. Well,
The lawyer's answer is, we don't know, because it was never litigated. That's why Anna wants to go sue. She wants that court opinion holding that her patent is valid and that it's infringing, right? On those facts, they settled. 99% of these disputes settle out of court. So we do not know if you're actually infringing. In my opinion, was there an infringement? I don't remember how I came down on that. The Idaho Potato Commission actually, somebody called me on that, and I actually rendered an opinion. I don't remember what it was, right? But the point is that we don't know. So here we go. Was Idaho Potato Commission using it first? Yeah. Are the marks confusingly similar? There you go, Aaron. See, that's what juries are for. This is what juries do. This is why we have the American judicial system. 3, are they related lines of goods and services? Fries and potatoes. Yeah. Right. See, there it is. That's the test. That's what you go litigate. Right there.
Who do I represent?
Yeah, right. And to Phil's point, and who do I represent? Lawyers are famous, as you know, for changing horses as the client may demand, you know? All right, so we got to move on. Second, you get past 1, okay, and I say, yeah, 10% chance only a 10% chance you're going to lose. That's a good mark, right? I'd say go. 2, can you register the mark with USPTO? See, we haven't even gotten to the question that all of you were thinking was trademarking until now. So the next question is, are there any prior filed live trademark registrations or registration applications at uspto.gov in a related line of goods and services for a similar mark? So there are some related tests, but they're different. The tests are different. In the first case, we're relying on my opinion to advise you on whether I think you're going to get sued and lose. In the second one, I'm opining on the likelihood, here you go, the likelihood that an examiner in the trademark office in Alexandria, Virginia, who's getting paid $22.50 an hour, and for whom English may be a second language, it's just true, is going to find that your mark is confusingly similar to one of the 50 other marks that we find in our search. See, it's a completely different calculus. Do you understand why? They're just different. So we may agree that the answer to 1 is, yeah, go. And we may agree that the answer here is no. But remember, trademark rights arise through use, not registration. What if I answer yes here and no here? Are you done? Absolutely not. Go. You just can't register your trademark. Let me pause and let that sink in. You can still use it, Jesse. You just can't register it. I would say 15 to 20% of my clients, this is the outcome. I say, yeah, use it, go. Nobody's going to sue you and you're not going to lose. But you can't register it, and here's why. They're completely arbitrary and different tests. But the perfect scenario for your exit is to answer both 1 and 2 yes. But it's not fatal to your go, no-go launch decision if this is no. Let's that sink in. Does everybody understand that? They're different, completely different inquiries. And lastly, have you secured the social media and domain name spaces around the mark? Again, you don't have to do that, but what's our goal here tonight? Prepare you for an exit. If you've done all 3 of these, you can use it without getting sued and losing. You've registered it with USPTO, and you've secured all of the social media and domain name spaces. Do you think, rhetorical question, is your brand more or less valuable to Google when they acquire you? You see the point? We're preparing you for an exit. We're adding value. Each of these steps adds $signs to your exit. They really do. You'll get more money on an exit if you can answer all of these questions yes. And they will ask you, in due diligence, Chris. Yeah, Chris, and then,
What would you count as a secure domain? I mean, if it was a .com, you have it, but you don't have the .net and .org kind of thing.
yeah, exactly, yeah,
Sometimes
yeah. You know, 10 years ago, I said to clients, don't do the crime if you can't do the time. No, I said, don't do the brand if you can't get the .com. 10 years ago, that was the answer, right? But now, because of search engine optimization, right, it's less critical to have the .com. But I still recommend that most buyers for your exit will ascribe value to the .com domain. So I would not say, if you called me, Chris, and said, Brad, we're yes here, I got everything but the .com, I would say, go, launch.
Well, I think right now with both Lance here in Boise.
Oh yeah, Aaron, yeah, sure. I don't think that's fatal. I've encouraged Aaron to get .com, but he can't. You may not be able to get the .com. So I threw out 1, 2, and 90% of 3 because you can't get the .com. I would have 10 years ago. I don't anymore. Sure. Yeah, very good. Because what they would go find who owns the .com and maybe buy it. Sean.
Another thing to think about is not a fatal issue by any means, but when we started our company, we always required 6 or 7 domain names. 30
Right. Sean's right. I usually recommend 20 that form what I call a picket fence around the brand. .com, .net, .info, .org, .tv, .mobi, .co, .cc. That's 8, and then a few more. We make a list of 20. And depending on your international expansion plans, we may throw in a few country code top-level domains. .fr, .ca, .mx, right? And now, I hate to even mention this because we're okay on time. Also remember that up until a year ago, how many things could there be to the right of the dot? A finite number. There were 23 generic top-level domains, .com, .net, .org, .info, and there were around 300 country code top-level domains, .tv, .cc, .co, .mx. Now, as you know, any word in the dictionary can go to the right of the dot. So we now have .insurance, .learning, .tires, .cars. So if you are the Hartford, would you be concerned if someone had Hartford .insurance? See, so now, unfortunately, this is now expanded because of they're called the new GTLDs, the new generic top-level domains. There are 1,900 of them. So if you're the Idaho Lottery, you might be concerned about .lotto. If you're Boise State, you might be concerned about .education. If you're Zions Bank, you might be concerned about .banking. I don't know. But the point is that for today, I do not include this in this calculus because it's still such an outlier. But 3 years from now, this will be an issue, and we will have to think about what are called the new GTLDs in this pre-launch decision in step 3. And the key here to answer these questions is to do a robust pre-launch search. That's it. I mean, that's the answer. That's how you do it. You do a pre-launch search, and you answer these questions. Can you use it without getting sued and losing? Can you register it? And then I ask you, have you secured all the domains in the social media space? Do you own facebook.com/Sean's LLC? And that's it. Do you own the Twitter handle @Sean's LLC? Do you? That's the issue. Okay. What have I done here? Oh, we're still on protect the IP. Okay, great. So I think we've talked about this. This is awesome. So to protect trademarks, you what? First you use it. Use creates rights, not registration. Use creates rights, not registration. As soon as Jesse puts up that website, what do we have, Jesse? And a trademark, right? Everybody get that? All we did is put up a website and advertise our consulting services. We have a trademark. Use in the United States create trademarks. Unfortunately, that's not true throughout the world. Just like patents, some countries, in some countries like China and Japan are actually first to file trademark jurisdictions as well. So we have to think proactively. If you have an international strategy for your trademarks, sometimes use is not enough. That works in the US and what are called common law jurisdictions, but some countries like Japan and China and others are first to file trademark jurisdictions. So we got to file there fast. Okay, so we've already talked about this one. Common law marks are those that arise through use, and registered marks are those that we register with USPTO. And this is a process of filing an application and a fee, like getting a patent, kind of. You file an application fee and a piece of paper with the United States Patent and Trademark Office, and if you do it right, 8 months later, a year later, you get back a registered trademark. But does the presence or absence of that registration affect your trademark rights? No, because trademark rights arise through, very good, Zach. Trademark rights arise through use, not registration. So why, you may be asking, do we register? Anybody wondering why? Why do we care? Look at that. It's almost like I planned this out. Here are the reasons we register trademarks in the United States. Number one, a U.S. registration is the gateway to international registration. Remember, Japan is the first to file. It will cut your costs by a tenth. It will reduce them by 90% if you have a gateway foundational U.S. registration or application on file before you move international. It just will. It just makes it's 1/10 the cost and the time. It just is. So a U.S. registration or application is the gateway to international registration, number one. The second reason you file a registration application is it creates avenues to better address cyber squatting. So when you don't do what we talked about and you don't get all your domains, and somebody sneaks in and gets, seansllc.info or whatever, if you have a registered trademark, then that gives you a remedy to address cyber squatting. You'll be far better off if you have you essentially have no remedy against cyber squatting without a registered trademark. Yes, you can try to get back a cyber squatted on domain with a common law trademark. You can, but it's 10 times as hard. I've done it both ways, and it's 10 times as hard if you don't have a registration. And lastly, Facebook, Google, Etsy, eBay, Pinterest, Instagram, and all the others will not give you the time of day if you don't have a registered trademark. If a competitor of yours has appropriated your trademark as a Google AdWords campaign, and every time someone searches for Sean's LLC on Google, and your competitor comes up in one of those sponsored links, you all know what I'm talking about, above the organic results, Google will not give you the time of day. You can file all the Google AdWords complaints you want based on a common law trademark, and they'll just simply say, when you have a registration, come talk to us. So yeah, sure, I have 10% of clients who never care about registration. They rely only on their common law rights. But 90% of my clients do care about international registration, do care about cyber squatting, and do care about being able to protect their marks on the internet. I don't know where you fall, but that's the test. That is the test. And that's the determining factor, in my view, as to whether you spend the time and money to register your trademarks. Remember, you have them through use. The question becomes, do you register them? And this is the test. Questions about this?
How long are trademarks good for?
They're very good. They're good forever, as long as you use the mark. Unlike patents, which actually do expire, and copyrights, which actually do expire, trademarks last forever, Jim, as long as you use them. And that doesn't mean maintaining the registration. That's why when you go and look, some are live and some are dead. That's why that's a fool's paradise. Dead doesn't mean anything. It just means you chose not to register it again or renew the registration, right? That's why question one is so important. So as long as you use a mark, you have a viable common law trademark right forever. All right, awesome. Oh, I just want to give you some examples of registered trademarks just to show you. Look at, I don't know if you can see what the arrow points to there. So what is the trademark here? What is the registered trademark? The color blue. So yeah, remember earlier that slide? Yeah, you can register colors as trademarks. There's an example. Boise State's famous blue turf is a registered trademark. Here is a sound. Ba-da-ba-ba-ba. I'm loving it. That's a registered trademark. McDonald's, there it is. The mark is a sound mark consisting of a 5-tone audio progression of the notes A, B, C, E, and D. I actually went out to a keyboard and typed out da-da-da-da-da because I didn't know what that was. So that's what it is. It's, right? It's da-da-da-da-da. And then lastly, here's another one. Here's a scent. This is a scent mark. So we got colors, we got sounds, and we got smells. This is a registered trademark. The mark consists of the coconut scent. So there you go. And there are others. If I'd looked, I could have found marks on what's called product configuration. The look and feel of a product is registrable as a trademark. But remember, kids, this doesn't make the trademark. This is just simply registration of an underlying existing common law trademark right. Yeah.
So when it comes to something as generic as the scent of coconut,
Right.
how does that actually
Trademark. Yeah. Register the trademark. Sorry. Yeah. Very good. No, I know what. Go ahead. I'm sorry. I don't mean to make fun. Go ahead. You're absolutely right. Go ahead. I know what you're going to ask.
So just like how does the enforcement,
Yeah. Okay. So here it is. Real quick. Here it is. So this is exactly what this is what this screen teaches us. Okay. Ready? So a company called FFS Holdings, a Delaware limited liability company, has proved to the trademark office that when consumers smell coconut, they think of FFS Holdings as the source of retail store services featuring sandals and flip-flops. That's it. That's the rubric. That's the test. Remember? Source, mark, consumers. Source, mark, consumers. So here it is. They've convinced the trademark office that when you smell coconut, and you see flip-flops in a store, you think of FSS Whole. That's it. You can do the same thing. If you make consumers think of your company when they smell strawberries, you can register strawberry as the smell of a trademark for your company. In fact, there are a lot of scent marks, a lot of them. Strawberries, cherry, yeah, pine. Sure. Does that make sense? That's so to your point, they're not trademarking a common thing. They're trademarking the scent of coconut in a very limited context. Consumers who see flip-flops in a retail store think of this company. They're not co-opting or having a monopoly on the scent of coconut. It's a very limited setting. Does that make sense? Yeah.
Only in the context of flip-flops, was that?
Yeah, well, Anna, more specifically, in that litigation, when we sue for trademark infringement, the court's going to be looking at your trademark rights in retail store services featuring sandals and flip-flop or sandals and related accessories, namely beach balls, insulated bottle and can open, that thing. That's called the services description. That circumscribes your trademark rights. That's like a claim in a patent. That thing, right there.
And what did you prove that? I mean, maybe that's too broad of a question.
Well, I file my lawsuit and I show to the court that the defendant is selling. You guys all know this. What do I have to prove the defendant is selling? And consumers are confused because of it. What's the defendant selling? Flip-flops. The defendant is selling flip-flops in a retail store. And what else are they doing, Anna? Not just selling flip-flops, but what else are they doing to confuse consumers? They're using the smell of coconut. I have my Scentsy right there, my Scentsy wax warmer right by those flip-flops, effusing coconut scent. And I go to the judge and I say, let's do the checklist. Coconut scent? Check. Flip-flops? Check. Consumer confusion? Check. Plaintiff wins. Yeah. Jen.
So who controls how specific that has to be?
The examiner sitting in the cubicle in Alexandria, Virginia, number one, making $22.50 an hour, and the judge who sits over the trademark infringement lawsuit.
So it's really
It's extraordinarily capricious and subjective, yeah. Yeah, it's extremely capricious. We'll file an application on almost two identical marks, right? Almost identical, except one mark will be just literally a word mark, and the other one will have like a stylized font, but like Captain Crunch. Okay, the word 12-point Courier font Captain Crunch and 18-point Helvetica Captain Crunch. File them. Examiner A says yes. Examiner B says no. That happens all the time. It's very subjective. Yeah. Oh no, I thought I had a question. Phil.
So hypothetically, would you, I guess, increase your case for filing if you would have every customer that walked out into a store? If you just said, hey, what does it smell like? They said coconut. You said great.
Yeah. See. Yeah. See, Phil said he's thinking like a plaintiff's lawyer. Phil said, so what you would do to win that lawsuit is the plaintiff would have people stand around the exit of the defendant's store and say, what did you smell when you went in there? And they would say, well, coconut. And what did you think of when you smelled that coconut? And they would say, well, the plaintiff. I don't know why this company's using it. It's obviously a knockoff. If you get 51% of the people to say that in a 10,000 person survey, you will win that lawsuit. You will win that lawsuit. If 30% say it, you will not win that lawsuit. That's how it goes. Yeah, it's called evidence of acquired distinctiveness is actually what that's called. But that's how you do it, Phil, with a survey. Yeah. All right. So here's an example of somebody who didn't do it correctly. Who owns applesucks.com? Oh my heavens. Chong Sam Lee owns applesucks.com. And there are others. Who owns microsoftsucks.com? Not Microsoft. A famous cyber squatter named Dan Parisi he's a hero in the domain name space. He owns microsoftsucks.com. Why can't Apple get that back? Why can't Microsoft get it back? Why? They've done nothing illegal. This is not cyber squatting. It's not illegal to register a domain name that contains somebody else's trademark, even if it has the word sucks in it. If you do it lawfully, you may do this. Obviously, microsoftsucks.com and applesucks.com. So what's the moral of that story? What's step 4? What's step 4? Anna has it right. Why wouldn't you immediately register Sean's LLCsucks.com, Sean? It's $8. Why didn't you do it, Sean? Because when I'm in doing due diligence on your company, and you give me this, because I ask for a who is on all your domains, and I say, Sean, why don't you own SeanSucks.com? What are you going to say to me? I didn't think about it. I screwed up. Right? You see the point. The point's made, right? Right. Including the sucks domains, I hope. Okay, good. This is what they're called, the sucks domains. I mean, there's a whole line of cases on the sucks domains, actually. That's just what they're called. All right, we're running out of time, so let's go quickly here. How do we protect our copyrights? Well, we register them. Remember that copyrights exist by virtue of the act of creating a copyright. It's a noun. We create them, right? Once they're created, we have to get ownership of them away from the author. That's step 3. And then lastly, we register the copyrights. Unlike trademarks, which exist without regard to registration, copyrights require registration to be enforceable. Trademarks do not. You may certainly, Jesse, sue for trademark infringement of a common law trademark. We do all the time. Copyrights, however, are different. In order to sue for copyright infringement, what's in the copyright bucket? Let's review. What's in the copyright bucket? Source code. Is that important? Website. Holy cow. Photos, text, songs, videos, movies, the entire metaverse of Star Wars. George Lucas's entire metaverse of the Star Wars thing is in the copyright bucket. Holy cow, is that important? Yeah. So George, like others, has registered all of his copyrights. And what that does, that doesn't affect creation or ownership. It strictly goes to the issue of step 4. Step 4, protect the IP. Register your copyrights. Register them. It's cheap. You can take a million lines of source code, and register the copyright for, are you ready? $35 with the copyright.gov. And that doesn't do anything for you other than give you a remedy in case someone commits copyright infringement. That's what it does for you. Protect the IP. Remember, theme here is not open source. Theme is protecting yourselves and preparing for that exit. So when they ask for the copyright registration certificates, Chris will hand them 30 of them or 50 of them on all your important IP. Yes, sir? No. Right. And see, this is why I bristle at the term copyrighted, because as a copyright lawyer, that means nothing to me. Some human being took a photograph, and by virtue of that process, some human being owns a copyright. You saw the case where the monkey took the photo? Did you see that case? A monkey took a photo. A monkey took a selfie. And the photographer went after the company that published it saying he owned the copyright. And the company wrote back and said, no, the monkey owns the copyright. Well, of course not. I actually did the research on it because I was curious, and the human being who gave the monkey the camera and set it up for the monkey to take the selfie actually owns the copyright. The law's pretty clear on that, right? So we have, it's true, the monkey does not own the copyright. I mean, I looked because I was curious. I actually emailed the photographer and said, dude, the monkey does not own your copyright. You should fight this. And he never responded, but I emailed him and told him that he owned the copyright. Pardon me? What? I did not have an email address for the monkey, although I sent him a LinkedIn request. And he's not yet responded, the monkey. The monkey has his own Facebook page now, by the way. Yeah. Exactly. Curious like George. I'm the man in the yellow hat. Well done. So in order to enforce, remember, step 4, protect, register those copyrights. So look at the stuff that's in the copyright bucket. Assuming the LLC owns it, no registration if you don't own it. Can't do it. It's actually fraud on the Copyright Office. If you submit a copyright registration application and you cannot prove that you own that copyright because you think you do, you had an independent contractor come in and write some code, and you paid him $5,000 for it, and you think, I paid him $5,000, I must own the copyright, and you send in a $35 copyright registration application. Guess what? When you go to litigate that, you will get in trouble for committing fraud under penalty of perjury. You sign that thing under penalty of perjury that says, I own the copyright. And if you're wrong, guess what? That's actually perjury. So you got to be right on this stuff. And so that's why it's important to timely register those copyrights. How do we protect our trade secrets? Well, I think we've talked about this. We keep it a secret, don't we, Sean? Don't put it on the break room refrigerator. Liberally use non-disclosure agreements. I tell my clients to give every human being who touches their idea 2 documents. An NDA, don't I, Karen? An NDA and an assignment of inventions and rights. An NDA and an assignment of inventions and rights. Everybody has those in their back pocket. And when you go talk to your banker, when you go talk to somebody, a partner, you pull out the NDA, sign it. Why? You don't have an issued patent. You got to protect that trade secret. You have them sign an assignment. Why? Because if they contribute creatively to the idea, you want to own it. Everybody gets an NDA and an assignment. Everybody. It's like a packet. NDA assignment. NDA assignment. With everybody who, well, not because everybody gets concerned about everybody. People who contribute creatively to the idea should sign both of those documents. people who contribute creatively. And there is no bright line test as to what that means. It's a case-by-case test. If they creatively contributed to the idea, the product, they should sign both. Okay. Lastly, what's our last step here? Well, we make money on the IP. You've done all 4 steps, now what? You monetize it. Holy cow, go out and make some money. It's time to have fun, right? We've done everything right. So the first thing we do is we maybe license it, and we've talked about that. My gosh, you go find people who are infringing and you sue them, or you tell them that they have to take a license. A license is simply lawyer speak for, I give you permission to use my stuff and you pay me without me suing you. That's all it is. It's a simple piece of paper. License agreements are 4 or 5 pages long. And they say, I own a copyright, I own a trademark, I own a patent, I give you permission to use it, to infringe, and I won't sue you, and you're going to pay me X dollars per year. That's it. That's all it is. But you're monetizing this IP. You can put it on the cloud, obviously, and make it available in some kind of a cloud environment. Many SaaS models monetize their IP that way, right? They're not doing anything other than logging in through a portal using a username and a password. But you're still monetizing your IP by putting it up in the cloud. You can sell it. You can flat sell the whole company. Sean sells his whole LLC. He gives the membership interests, everything, all the IP, everything to Anna for $10 million. And he's done. He's out. And you transfer the whole thing. That's what the Instagram exit was. You might stay around for a while as a consultant, you know, as is typical. Or, oh, I'm sorry, this is that one. Or you could just sell the discrete IP. You can certainly sell patents. There's a robust market in selling patents. If you found a patent that you liked, you go buy it. What does buying a patent that you like do for you? Well, number one, it gives you a defensive position because you now own the patent, but it also permits you to go out and assert it and license it and monetize it if you want. Very robust market in buying patents, just like any other asset that you can monetize. All right, here we go, back to the due diligence slide. Here, see how it all comes full circle? So you're being asked due diligence now for your exit. And they say, schedule out all your IP. Well, you've already done that. You did that in step 2. It's what's in the buckets. Prove that you own the IP. Well, you've already done that. You did that in step 3, own the IP. Show me all the contracts you have that affect your IP. You've already done that when you did steps 2 and 3. Identify it and own it. Show me that you've protected that IP to create value. You've already done that. You did it in step 4. Show me how you've monetized or will monetize your IP. You've already done it because you did it in step 5. So all you're doing by following these steps is preparing now for an exit so that you will not have a horrible awakening during your due diligence experience with the lawyer. Okay, I think let's see, elephant in the room, blah, blah, blah. Yeah, you might say it costs too much. I have to focus on sales and revenue. Okay, you can tell I obviously am passionate about this stuff. My view is that the total expense of doing trademarks, copyrights, patents, and domain names relative to the value you get on the back end, it shrinks. I mean, my view is that this should be a priority. So I don't care whether you hire me or you do it yourself. It doesn't cost too much relative to the ROI. It just doesn't. Number 2, I have to focus on sales and revenue. Yeah, but you also have to focus on IP and preparing for your exit. Yeah. 3, I need to raise money. I can't focus on this. I got to meet with the angels. Yeah. But do you think, anybody watch Shark Tank? What do the sharks ask? Is it patented? Sharks have no idea what that means, but that's what they ask. So when you go meet with the angels, what are they going to say? Is it patented? Do you have a trade? Is it trademarked? And you're going to say, yeah, because I did step 2 and 4, right? Prepare now for that exit. All right, where are we? I've got to get to my hypothetical. Oh, man, we're going to skip to the hypothetical because I love it so much. Okay, let's all read this together. And I'll send you the deck. It's no big deal. We're out of time. Email me. I send you the deck. We talk on the phone, right? I send you the deck. We talk on the phone for free. For free. All right, here we go. Stanley has an idea for a new and revolutionary technology that combines 3D printing with nanorobots to print custom self-wear shoes that shine themselves and adjust to the contours of your feet during the day. Well, that's genius, right? Stanley calls the process, I love it, nanny petty. Oh, come on, it's better than that. Nanny petty. All right, his college roommate helped come up with the idea. Stanley gives $5,000 to his nephew to code the print program. The nephew downloads kernels from GitHub and SourceForge. He builds the app and gives Stanley the source code via Dropbox. Stanley gives a college student $250 to draw a logo and design a website for end users to download the code and print their shoes. Stanley also, being vertically integrated, smart businessman, sources the printer hardware and the nanorobotics laced shoe composite. Isn't that a great phrase? The nanorobotics laced shoe composite. 3 months after Stanley launches, Dr. Scholes announces a similar technology. Holy cow. This coincides with a Dropbox data breach. Uh-oh, right? Zappos.com, of course, contacts Stanley and wants to buy the technology. They send their high-priced lawyers to Boise armed with their due diligence checklist. What do we do? Let's just issue spot for a minute. This is what we do in law school. You issue spot, so let's issue spot together. All right. So first question, does Stanley own the invention? Does Stanley own the invention? Stanley, the human being Stanley. Well, he might own some of it, but who else probably owns part of it? See? So we've already spotted a problem. The first thing that lawyer is going to say is, Stanley, you don't own this. But even more fundamentally, I'm going to say, Stanley, where's your LLC? Am I buying stuff from you that you've been schlepping around in a cardboard box the past 5 years? I want to deal with a Delaware C. Where's your Delaware C, Stanley? We don't have one because you didn't do step one. All right. So first of all, no LLC, no entity. Bad, 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 bad. Because when he gets sued by Shoals, they're going to sue him, right? They're going to sue him. And he doesn't have an LLC. All right. So he's got this idea, but the college roommate is probably a co-inventor and probably owns part of the patent. So he calls the process nanny petty. What am I going to ask him? Do you have nanny petty? Well, yeah, patent, but nanny petty. Do you have nannypetty.com, .net, .org, .info, .us, .tv, and so on? Do you have all those? Let me see, Stanley. Show me the who is. How about this? Have you filed a federal trademark registration application on nanny petty? Have you? What about international trademark registrations? Where are they? His college roommate, we talked about that. Stanley gives $5,000 to his nephew to code the print program. So the nephew codes this. Who owns the copyright to the print program? The copyright. Nephew, right? No assignment. Where's the assignment? Where's step 3? Where's own the IP, Stanley? The nephew downloads kernels. This happens every day. We all know this. Anybody that's a coder knows this happens. The nephew downloads kernels from GitHub and SourceForge. Why is that significant? Why do we care? What are those? Those are open source repositories. All the code on GitHub and SourceForge is open source by definition. When you download it, you sign a license agreement that says you may not render the resulting code proprietary and you can't get patents on it as a general rule. So you don't own it. So even if you've gotten the assignment from the nephew, the fact that he used open source modules to build the code renders him incapable of having a proprietary right in the code. Holy crap. Okay, so he builds the app and gives Stanley the source code via Dropbox. This is suspect because Dropbox gets hacked. So assuming he can own it, has he registered the copyright so that he can go after all the people who've downloaded the code off the Dropbox hack? Don't know. Don't know, Stanley. So 3 months after Stanley launches, oh, wait, draw the logo. Gives the college student, who owns a logo is a drawing, right? It's a drawing. Who owns the copyright to the logo? See what I mean? So a logo has 2 lives. It's copyright and trademark. See how subtle it is? It's copyright and trademark because the logo is a picture. So this guy owns the copyright in the logo. Stanley can get sued for copyright infringement by that student. Even though Stanley may be using it as a trademark, Stanley doesn't own the copyright in the logo. They're different constructs. Okay, let's see. Where are we? Okay, good. Stanley also sources this is just a red herring I threw in there for fun because I like the phrase nanorobotics/shoe composite. That's the only reason I threw that in there, because I like that phrase. Okay, 3 months after Stanley launches, Dr. Scholes announces a similar technology. So they're gearing up to sue him or do something, or they're looking at him because they launch a similar technology. What else do you think maybe happened? You think this coincides, maybe they were involved in the hack. So maybe they're using source code that infringes on my copyright in my source code because we both got it off Dropbox. But that assumes Stanley owns it, and it assumes it's not open source. Zappos.com contacts Stanley and wants to buy the technology. They send their lawyers to Boise armed with a due diligence checklist. There you go. Those are the issues, kids. You think Stanley's going to make a sale to Zappos? No way. Absolutely not. We are officially out of time. So, Elizabeth, I'm going to turn it back over to you. Is there some conclusory things we need to do? Were there any questions or anything? No questions from the webosphere, which is highly disappointing. Those of you who are here live, however, can email me. I send you the deck via PDF. You read it. You call me with questions. I give you free legal advice. It's a win-win. All right, so we're done. Wait, Karen, go.
We need you to fill out a survey, please, and then you can drop them off outside.
All right, kids, have a good night.
Can we give a big hand of Brett? Made the law interesting and entertaining.